I'm delighted to introduce to you the next set of speakers, Mr. Nicholas Wong and Ms. Junyi Chen. They're both partners at Blaney and McMurtry in downtown Toronto. A little bit about Nicholas. Nicholas' practice combines extensive experience in intellectual property portfolio, development, and IP litigation with an expertise in business development and negotiating commercial contracts for clients in the area of pharmaceuticals and other health sciences. Nick has previously conducted research in cancer treatments and has worked within the regulatory and quality control areas of the pharma industry. Ms. Junyi Chen practices intellectual property law with an emphasis on patent and general IP matters in the area of pharmaceuticals and other health sciences. Junyi is a registered patent agent, registered trademark agent in Canada, and has extensive experience in patent and trademark matters and licensing. Please join me in welcoming Nicholas and Junyi. They'll be presenting to us today on challenges and opportunities of IP in the cannabis industry. Nicholas and Junyi, please take the podium.
Hi, Charles, thank you.
I'm just going to wait here.
So the impetus for our presentation today is really, there was an article published in Bloomberg probably about 2 months ago now. And what it did was it talked about how there is let's go back a bit. It talked about how there is a race in the cannabis industry to secure IP rights in a bid to appeal to investors. But at the same time, it also talked about the difficulties that cannabis companies have in actually getting registered, say, patent applications because of the long-standing use in the black market. And so despite the fact that many companies tout their IP, it really focused on some of the issues that these companies face going forward. And so what we thought we would do is we would prepare a presentation that takes a look at some of the trends in cannabis IP application filings. We'll take a look at some of the strategies and some of the challenges and pitfalls that some of the companies have faced when it comes to applying for IP protection. And then we'll take a look at some of the options for securing IP rights in cannabis. So the industry and market review, I think we can pass over that today. I think the fireside chat this morning was very informative. We'll give a very brief IP overview, but we'll just focus really on the meat of the issues here. We'll spend some time talking about patents. We'll look at the trends in cannabis patent application filings, some of the strategies. And then what we'll do is we'll take a bit of a tangent where we'll look at the road, what we call the road to innovation, which is really like contract considerations. Because a lot of companies, when we look at the materials out there, a lot of places that have talked about filing for, say, patent applications after you've already come up with patentable subject matter. And so the issues that they deal with is really about framing this subject matter and how to apply for your IP protection. But what we wanted to do was really take a step back. And so when you're in the position of the company that is doing the research to work towards something innovative and something that could be patentable, how do you protect your rights there so that by the time you come to applying for the patent, that you actually have all the rights secured? And so we'll take a look at contract considerations as they relate to employment agreements, development agreements, and clinical trial agreements. We'll spend some time talking about plant breeders' rights and different enforcement strategies around those rights. And then we'll spend a bit of time talking about trademarks